Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, will then for the Commonwealth. Draw near, give attendance, and you shall be heard. Now see the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. I assume that's working. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Neyman. To my left, Justice Tan. We will be hearing 5 cases today. The rules of argument are straightforward. 15 minutes per side and no rebuttal. In the event that there are parties who will be splitting argument time, you should let us know at the outset, although we also have some notations that might be accurate about that. We've read your briefs with some care, so if you want to get right into your argument and not spend a lot of time on the facts, that might be best, but it is your time, so you may do with it as you wish. The first case we will hear today, this is number 24734, is Commonwealth versus Ahart. And we will hear first from Attorney Waryash.
Morning. Michael Waryash for Mr. Ahart. This is a case that's before the court on consolidated post-conviction motions. The first of which I'd like to touch on is the first in our brief as well. It deals with gunshot residue admission of both the evidence itself and testimony about that. This was presented below in a Rule 30B motion where the decision of it has flaws. The first is a legal error as well as there are abuses of discretion. I'm going to touch on the legal error first, as I think it's important to our understanding of the GSR issue itself. In this case, the Commonwealth's introduced evidence through expert Mr. Biello. Mr. Biello testified that the presence of GSR on sample stubs taken from a sweatshirt would say the person either fired a weapon, they were in close proximity to a weapon being fired, or they had just handled a weapon that had been fired. This third aspect, that they had just handled a weapon being fired, is inconsistent with prior jurisprudence in Paito Hieng. In Paito, the expert testified that persons wearing the clothes in that case had either discharged a firearm, been near a discharged firearm, or had come into contact with something that had gunshot residue on it. That implies transference, and in this case, transference is key.
Didn't the expert, he was asked on cross-examination about that, not necessarily the word transference, but he agreed. He was asked a question, if 2 or 3 people are in a very small room and somebody fires a firearm, it can get all over the place. Is that correct? Answer, yes, that is also correct. So wasn't that answer consistent with the case law that you're speaking of?
It's not really. That deals with blowback. And blowback was something that trial counsel had mentioned. Blowback is actually the second one of those 3 things listed by the experts in both our case and in Paito, that you're near a discharged firearm. But there's also this idea of a transference, that objects with GSR on them can transfer GSR to other objects. In this case, we retained an expert, Mr. Danis. He testified about what he called the expected transference of GSR from the firearm to the sweatshirt because they were in direct contact. So in this case, the police arrive at the scene of an incident, all parties have fled, they find the sweatshirt, they open it up, and wrapped inside it is a firearm. Now, here, it's impossible to separate that contamination there. There was talk about contamination as well, dealing with possible police contamination, but there was no talk about this actual direct transference that the police observed themselves when they recovered the evidence of the firearm itself would have GSR on it and transfer it to the sweatshirt. Mr. Biello noted that anything before that would be speculative. It would be hard to determine if that sweatshirt had GSR on those sample stubs before it came into contact with the firearms.
You had an expert who testified on this?
He did not testify. We requested an evidentiary hearing, and I renewed my written request at the hearing itself because I felt that it would be instructive for the court to testify. And there was no contradicting expert presented to say that this would not be the case or not how it would occur. But this was something that was different because the way that Mr. Biela testified, each one of those possible outcomes were all pointing towards culpability for Mr. Ahart for possessing and controlling the firearm in the vehicle that night. And that was central to the Commonwealth's case. There was an incident earlier that evening in another part of Cambridge that the shots were discharged. The argument was that Mr. Ahart then, he discharged the firearm there, carried the firearm to the site of the second altercation on Harvard Street where it was discarded. Now, each one of those things, whether he was with people who may have fired the weapon, made it more likely for him to be the person who in fact was the one to be convicted.
Didn't he, counsel, though, wasn't his non-blood DNA found on the trigger of the gun?
That's a very good point, Your Honor. The judge did make a finding on that, and she held, in terms of prejudice, she noted that trigger DNA was comparatively more damaging to the defendant. So we're talking here about non-blood DNA, so skin cells that were on the trigger. And in arguing I was incorrect on GSR evidence, the judge noted that there was testimony by one of the Commonwealth's forensic experts about DNA transference. But she doesn't mention in here that DNA transference of skin cells could have occurred as well from the wrapping of the sweatshirt. So there was testimony about skin cell transference. So the jury could have rejected that. There were no fingerprints on that trigger area or in the firearm as a whole, the magazine, casings, anything. So there was no link there. But that the jury could have believed that the sweatshirt being wrapped in, wrapping around the firearm would have caused that transfer of skin cells to the weapon itself. So that's an area that I believe that she abused her discretion in weighing the evidence that was presented, Your Honor. So one area that I did mention in my brief as well is that there's a case I cited, Commonwealth versus Medley. And Medley talks about CSLI evidence, but I think it provides a really important point here about the use of GSR evidence in this case. It talks about overestimation for the jury and the need for a candid explanation of the accuracy of a particular location method being used, which must by necessity include its limits as well as its strengths. So here we have a case where this evidence comes before the jury and they're not instructed on a key aspect of it. Now, my opinion is that trial counsel should have moved to exclude this evidence fully, and if not, I guess limiting instruction could have been presented. But here, full exclusion, I believe, is necessary because for the evidence to have to come in, it has to be relevant. It has to make a proposition more likely or less likely. Here, this evidence, this GSR in the sweatshirt, doesn't make Mr. Ahart's possession more or less likely. Because again, we don't know what the state of the sweatshirt was. If GSR was present where the swabs were taken on that sweatshirt prior to the time of being wrapped up. Now, the case against Mr. Ahart, was also linked up here. There was no eyewitnesses. So Mr. Danis does note in his affidavit that the only way to confirm the possession in this case, or that Mr. Ahart fired this weapon, is through eyewitness or video evidence, and that was entirely lacking here. The Commonwealth, relied on this evidence at trial, and this evidence was also noted in the sufficiency argument as well by this court during Mr. Ahart's direct appeal. So it was very relevant.
Do we know how many places on the gun were swabbed for DNA?
The DNA samples came from the sweatshirt. So there were they came from sample stubs taken from the sleeves.
There's non-blood DNA on the trigger of the gun. I'm asking how much of the gun was swabbed for DNA?
I don't believe that was in evidence, Your Honor.
Were skin cells found anywhere else than the trigger on the gun?
My recollection is they were not, Your Honor. My recollection was they were not. There was no evidence presented of that. The evidence was presented to the trigger area, and that there were blood DNA otherwise, Your Honor.
And there was no testimony about whether, and that was from what? From the barrel of the gun? Where was the blood found on the gun?
I believe it was on the side part of the gun, Your Honor. I'm not sure what the term would
I
be.
mean, I'm just trying to figure out, you've said that can't render any error harmless about the gunshot residue, because DNA could have, skin cell DNA could have transferred from the sweatshirt, and I'm just trying to figure out, transferring only to the trigger strikes me as unlikely, although I have no data on this, of course.
Yeah, I believe it was the way the evidence came in at trial as well, Your Honor. If I could also, just while we're on the topic of expert use here, the third argument talks about this black cylindrical object, and at trial, Detective Lyons testified about it. He testified without certainty, and no objection was made. He testified this black cylindrical object seized from the vehicle was some kind of accoutrement to a firearm, possibly a flash suppressor. That was not the first time he testified about this object during a suppression proceeding. He testified that officers initially believed it was a silencer, but he didn't believe it to be so after further inspection. His testimony should have been objected to. It should have been excluded. It was speculation about what an object was without certainty. It does not meet any of the 5 foundational requirements under Barbosa to be accepted as expert testimony in this instance. It did nothing to assist the jury because it was only speculation. There's no record that a qualified expert had reviewed this item. His background with this item was not laid. And again, it seems he was speculating upon its use. We don't know if it was a firearm accoutrement at all, or let alone one that could have fit the Harvard firearm, in this case, that particular 9mm. So trial counsel should have objected to it. Trial counsel also did not do his own investigation of it by seeking funds to hire an expert to review that weapon.
And you're saying trial counsel was thus ineffective?
Yes.
So what about trial counsel's averment in the affidavit where he said this was a strategic decision? I wanted that, whether it's a silencer, accoutrement, or that piece was in the back seat of the vehicle near someone else, and my strategy at trial was to tie the gun to anyone else other than my client. How can we say that that strategic decision, well, number one, it was a strategic decision, and number two, how can we say that that is incorrect or, as a matter of law,
So preliminarily,
as a matter of law, it meets the first prong of Safarian?
correct. Preliminarily, we have an investigation that didn't occur in this matter. So the decision that he was making was made in the absence of information. So if he would have found out, for instance, that the firearm accoutrement that was alleged, had no such function or was entirely unrelated to the 9mm in this case, he wouldn't have had to tie it to someone else. It would have been excluded, and he could have made that argument. Even without that, that argument did not benefit Mr. Ahart because contraband may be possessed jointly. So this accoutrement is found.
Was the jury instructed on that?
I believe they were on
joint possession?
Sorry.
And in this case, I don't believe they were, Your Honor. I'd have to look back at the record, but
Can I ask, because your time is short, this change in the docket, there's lots of reasons to think that it wasn't entered on February 26, 2011, including the fact that down below it talks about a bail hearing in what looks like the same order, although of course it's typed into a docket. I have no idea when and how it was typed. Do you have any idea?
I don't. I was a little surprised myself by the way the document looked with whited out areas on it, with dates that were not contemporaneous to the imposition of the sentence. I had spoke with Clerk Pasquale, who was the session clerk, And she gave her reasoning to the Department of Corrections about 6 months afterward about why she could not make the change that they requested in the docket. And also trial counsel for that period of time, he gave an affidavit about what he had done. He had argued vociferously points about why this should not be an ACC 3-level offense. So what we asked for was that the record be reconstructed according to Rule 8, and that did not occur in this case. That a hearing did not take place. So some of the doubts, I think, could have been resolved if we would have had the ability to question the different people who were available at that time.
And the copy of the minimus, is that what was provided to you in discovery? Like, where does that come from?
The court's files.
Do you have any idea why the section number is whited out and then typed in?
I do not. That's how I found it in the file. If there are no further questions.
And you don't know why the return is signed 5 years after the minimus issued?
I do not. And that clerk who did eventually sign it was not the session clerk who was there on the day that the sentence was imposed.
Well, I don't know about that. You're saying that even though it says, well, you're saying the assistant clerk magistrate who signed it, even though that part is dated 2011, wasn't there in 2011? Or down below where the deputy sheriff signs it?
Which page?
This is on 344 of the appendix. Do you see where I'm?
The assistant clerk magistrate was not Ms. Pasquale. So on page 342, we see Ms. Pasquale's signature as the assistant clerk / magistrate, and then we see a different signature on the one in page 344.
And where did you get 343 and where did you get 344? Do you know?
Those are from the court files.
Both of them are.
Both.
Okay. Your time has expired, and I see no further questions. So we will hear now from Attorney Lee.
May it please the court, ADHE Lee from Middlesex on behalf of the Commonwealth. Trial counsel in this case was not effective in the defendant's 6 motion for a new trial when he did not challenge the GSR testimony or when he did not hire an expert. I agree that the third scenario from Mr. Biello was not super consistent with Pai Tu Hong, which was 2 years after the trial. But like as Justice Neyman talked about, in cross, he did talk about acknowledge the possibility of transfer, and there was even better cross on volume 3, page 11. The expert was asked, a police officer who had been at a shooting range touches a piece of clothing shortly after. He acknowledged that would have possibility of GSR transfer or contamination. That's exactly what the defendant is now arguing.
What page was that?
Page 100 of volume 3. So if you look at the testimony altogether, including Mr. Zambella's principal transfer on DNA and the cross-examination of Biello and the Biello's 3 scenarios or the relevance of presence of GSR, that shows that it's consistent with Pai Tu Hong, which is 2 years after the trial. There was no error. And in any event, as Justice Tan mentioned earlier, the non-blood DNA on the trigger would have showed there's no substantial risk of miscarriage of justice. And back to Justice Rubin's question earlier to my friend, on volume 4, page 67 to 68, it shows that the slide and the grip, there was positive blood, and that shows a mixture of DNA profile. The defendant was a potential contributor. But on volume 3, page 66 to 68, that's the part that shows that barrel and trigger, there was no blood, but the defendant's mixture, major profile DNA was found on the trigger, and there was no blood on the trigger. So that combined together, that shows this non-blood DNA where the defendant was the major contributor was on the trigger. That showed that he possessed that firearm that night.
Unless the skin cells transferred from the sweatshirt.
That's also a possibility, but that's not a single evidence here. You also have the defendant being close proximity of the firearm and all the spent casings. He was involved in the group fight. His injury on his lower left part of his body is consistent with the cut on the sweatshirt. All these scenarios all together show the defendant was the one who possessed the firearm that night. And as to the cylindrical object, the defendant, as Justice Neyman talked about earlier, defense counsel needed a testimony to show that it was the rear passenger who possessed the firearm. Without that cylindrical object, it's harder to tie that firearm to the rear end passengers. To have that rear end passenger as having a firearm accoutrement, that makes it more likely that that was the person that possessed the firearm, but not the defendant. That was a reasonable strategic choice that he should be upheld. And finally, as to the docket, if you look at the back of the indictment, which is contemporaneous record of what happened in court that day, there was no hearing on February 16, 2011. There was no reduction from 2011. It was clear from the record of that day, the back of the indictment, and all the filings afterwards from defense counsel, many defense counsels, and from this court's 2 opinions affirmed on AC3 conviction. There was no reduction done that day.
Can we talk about this minimus for a second?
Yes, Your Honor.
So there's 2 of them. I had only noticed one of them. There's 2 of them. The first one at 343 of the record appendix.
Yes.
Looks like it was signed by the right person in 2011.
Yes.
Looks, although the date isn't filled out, like some deputy sheriff signed it, maybe then. And it says that he was convicted of the crime of armed career criminal, Chapter 269, Section 10, parentheses A, end parentheses. The next page is a minimus. The section has been whited out, and someone has typed in 10GC, which is the 3-time armed career criminal. I don't know what 10A, I just looked. It's not, I'm not even sure it states a crime, 10A. And of course, someone has signed it saying it's 2011, but that seems false. And at the bottom, you have a deputy sheriff who at least had the decency to date it 5 years later. What is this all about?
So 2 responses. Number 1 is the defendant was convicted of 10A and 10GC, which is IACC 3. So both crimes are reflected on the minimus. That's why you see a 10A there.
I don't see 10GC on the minimus signed by supposedly the correct.
Right, so the defendant was first convicted of 10A, which is in 2009.
Oh, I see.
And then there's a second trial in 2011, which is the ACC portion. That's why you have 2 minimus, because when he was first convicted in 2009.
Okay, but this minimus, this second minimus, is signed by someone who wasn't present, right?
So usually when MIT happens is where the court will issue a MIT, or the clerk will sign it, issue it to the Department of Correction, and the sheriff's there would sign off on it to show that it was received. So that's usually what happens. Exactly what happened in 2011, it's unclear. Bottom line is there was the back of the indictment and all other records showed there was no reduction done on February 16, 2011. And the defendant.
But you have no explanation for why someone created a new minimus, if that's what this is, for the armed career criminal portion.
No, Your Honor. But as to the 2 minimus.
And how do you understand the docket entry that says, whatever, 2 crimes, and is dated 2011? How do you understand that?
The docket?
Yeah, there's this docket entry. Right, that I'll have to find it. There's a docket entry that they refer to that says, hold on.
So the docket in this case that reflects the ACC2, which is 10GB, Our suspicion is it was created when the Superior Court docket went from paper to digital, and that's when the error happened. But if
Here we are. It's dated February 16, 2011. This is in the record appendix at 20. And it reads correction date, February 16, 2011. Charge number 2, firearm violation with 2 prior violent drug crimes, C-269, Section 10G-B.
So our suspicion, at least that was the one presented to Justice Pierce, the lower court judge that issued on this ruling, was in 2017, the defendant was briefly released by Justice Billings when there was a Rule 30A motion. And when the defendant was later committed again because he committed another crime in Essex County, that's when there's a new entry there. And we believe that's when things went wrong.
Why would someone put a new entry backdated 6 years and put the wrong crime and also say that the judge is Whitehead?
And that's exactly when clerical errors happen, and it happens, unfortunately, all the time in both district court and superior court and juvenile court as well. And this is why Rule 42 is necessary for the Commonwealth or the defendant to correct the docket, and that's what happened here, where the Blackne indictment and all other filings and this court and the lower court rulings all show the defendant has been convicted of AC-3 without reduction from Justice Whitehead for the past 15 to 20 years. It shows that the defendant was convicted of AC-3. His conviction and sentence was proper.
In 2016, excuse me, was the defendant transported to Superior Court for any hearings on any of the motions for new trial?
I believe so, yes. That would be the one where there was the motion for Rule 30A motion at the time when...
So the minimus travels with, the expression is that the minimus travels with the body. It travels with the defendant. So presumably the minimus was taken from the sheriff to the clerk at the court.
Yes.
Presumably someone then noticed an error in there and made the change.
Yes, and that's why
It'd be
Justice...
nice if so the docket does reflect, well, it reflects in 2011 correction date, but perhaps that correction wasn't made on the minimus until 2016, is my guess, but we don't know.
Right, but there are a lot of errors in this docket because it is the long case with many motions. What is clear for Justice Pierce, who denied this motion, who was the regional minister of justice in this case, was that the Blackne indictment, which is the one that controls the Superior Court docket, showed that there was no hearing done on February 16, 2011. Simply that day stay was revoked. The sentence, which is ACC 3, 15 years to 15 years in a day, was placed and went full effect. There was no error here.
Well, there was an error.
There was no error. Yes, there was error in the docket, but the Chief Justice Pierce did nothing wrong in this case.
In trial counsel's affidavit, actually, he states that he asked for the reduction, but he never states that, in fact, the judge gave the reduction, correct?
That's exactly right, Justice Tan.
Do you think we should eliminate our presumption that dockets are correct?
No, Your Honor.
You just said there's lots of errors in this because it's a long case. All our cases are long cases.
Exactly, and that's on the parties to bring that error to the court's attention to address that issue.
Okay, so you should have brought to the attention of the court that it says 2 and GB, and really it should be GC, but you didn't do that.
I agree. We should have done it years ago, but when we noticed it, we did file a motion to correct the docket in this case, along with the defendant's opposition to the defendant's Rule 29 motion. If there are no further questions, the Commonwealth rests on its brief.
I see none. Thank you very much.
You both.
Excellent argument, both of you. And the case is submitted. The next matter we will hear is number 24646. This is Commonwealth versus Blackne, and we will hear first from Attorney Gautier.
Good morning, Your Honors. May it please the Court. Edward Gauthier arguing today on behalf of the defendant. The defendant was convicted of assault and battery on a person over 60, causing serious bodily injury for pushing the victim down a flight of stairs. At trial, the defendant testified that it was an accident. The victim testified that he was pushed. The first issue was, based on that evidence, did counsel render ineffective assistance of counsel for not asking for an accident instruction? Of course, the first sub-issue here is whether he was entitled to the instruction. We believe that he plainly was under Commonwealth v. Jewett. He testified it was an accident. He told the police it was an accident. In fact, the Commonwealth during the charge conference told defense counsel that this was not self-defense. This, in fact, was an accident. So I believe the defendant was clearly entitled to an accident instruction, and the Commonwealth does not argue otherwise. The second sub-issue is why prior appellate counsel argued this issue directly to this court rather than filing a Rule 30 motion. My guess is he believed that the ineffectiveness appeared indisputably on the record based on conversations between defense counsel and the court. Before the evidence came in, page 37 on the first transcript, he says, Your Honor, based on how the evidence comes in at trial, I'm going to be asking for an accident instruction. The defendant testified it was an accident, and then at the charge conference, after being told by the judge and the prosecutor that this was an accident, he decided not to ask for an accident instruction, believing that the assault and battery instruction, the model instruction that was given, was sufficient. So we have two conflicting things. We have his statement that he believed it was sufficient, but then we have his pretrial statement that he was going to ask for the accident instruction. The evidence came in accident. We can't speak to why defense counsel didn't ask for the accident instruction, but if the court does find that a Rule 30 was not required to look into the mind of defense counsel, then the real issue in the case is whether the standard assault and battery instruction is sufficient to convey to a jury that the Commonwealth must prove beyond a reasonable doubt that it is the burden on the Commonwealth to prove lack of accident beyond a reasonable doubt. And if you look at the instruction on the elements that was given, all the judge says is 3 words. If he does it on purpose as opposed to accidentally. However, the model instruction at 9.100, the accident instruction, does several things that the assault and battery instruction does not do. The model instruction draws the jury's attention to the issue. It defines accident. It reminds the jury they must specifically find that the defendant did not act suddenly and without intent, which exactly mirrors the defendant's testimony. In terms of strategy, there are many decisions a trial attorney can make at trial that can backfire. We hear complaints all the time. My attorney didn't call a particular witness or follow this particular line of questioning or introduce a particular medical record. All of those things can backfire to the detriment of a defendant. But when you have a defense, having the instruction for that defense read to the jury cannot do harm. The question is, can it do so much benefit that failure to do it can raise a substantial risk of a miscarriage of justice? I'd like to do an analogy on this with self-defense. I think this panel would easily accept that if the opening and closing statements by defense counsel was self-defense and the testimony was self-defense and the attorney prior to trial said, Your Honor, just to give you a heads up, if the evidence comes in the way I think it will come in, we're going to ask for self-defense, and then didn't ask for self-defense, I think we would all agree that that attorney made a mistake. So really the question is, did the failure of an accident instruction in light of the elements instruction that was given, did that cause a substantial risk of a miscarriage of justice? Looking at the standard here for substantial risk, the evidence shows that the victim testified it was a push, defendant testified it was an accident, there were no independent witnesses, accident was the only real defense based on the defendant's testimony, and as stated by the Commonwealth at the charge conference, accident is the only defense for the push on the top of the stairs. Trials counsel stated in his opening statement it was an accident, saying specifically, if anything, this was an accident. The Commonwealth, in its closing statement at 6 different places, said this was not an accident, and the Commonwealth also argued not self-defense, and although trial counsel did not say the word accident, he did describe the incident on the top of the stairs as an accident. Before moving on to issue number 2, I would ask the panel if there are any questions on issue 1.
Yes. I don't see the accident here. I think accident maybe is being used in 2 different ways. His testimony was not that he touched the guy by accident. It was that he didn't touch him at all. It may have been an accidental fall in the sense that if the person who was injured, the putative victim here, stepped the wrong way on the stairs, he might have accidentally fallen down the stairs, and that would be an accident. But it wouldn't be an accidental touching, which, as I understand it, is what the accident instruction is about.
The accident instruction defines accident as an unexpected happening that occurs without intention or design on the defendant's part. It means sudden,
The original
unexpected
instruction,
event.
the main instruction, which is consistent with that, isn't it that the touching has to be accidental?
Yes.
Rather than, but there's no touching here, according to the defendant. He raises his arm.
And touches the arm of the...
No, the other guy is touching him already.
Yes.
He's moving away from him. He's not touching him. He's raising his arm because the guy's hand is on his shoulder. How is that an accidental touching?
The testimony from the defendant was that the victim came up to him, put his hand on his shoulder, and it's not properly reflected in the record because the defendant showed the jury what he did. And he says, in reflexive response, without any intent, he lifted his arm just reflexively, without thinking about it. He accidentally touched him.
No, he didn't say he touched him. He said he lifted his arm. He didn't say, and my hand brushed him or anything else. He said, like, the guy lost his balance and fell down or something, right?
That's an accident.
It is an accident, but it's not an accidental touching, I don't think.
But the defense, so in the elements instruction, it says a person intends to touch another person if he does it on purpose as opposed to accidentally. So the assault and battery instruction deals directly with the accidental touching. The model instruction on accident requires proof beyond a reasonable doubt that what occurred was not an accident. That what occurred was not an accident.
I think it's not a touching. It's not a battery of any kind. If someone distant from you accidentally falls down the stairs, I understand he wasn't distant, but I mean, I'll have to look again, but I don't see how there's no need for an instruction that something that doesn't involve a touching is an accident. If it doesn't involve a touching, there's nothing to talk about. It's not guilty.
I guess the question is, what did the defendant actually testify he physically did? And my reading of the transcript is that the man came up, touched his arm, that he lifted his arm, which caused a touching, which caused the victim to fall.
Well, I don't see that it caused a touching. It might have caused a movement of the other guy's hand. Maybe that counts as a touching, even though they're already in contact. That may be. That seems like a complex. I mean, I'll have to read the testimony as well.
I think overall the question that we're raising here is, was this an accident as opposed to an intentional touching? And I guess...
And doesn't the assault and battery instruction encapsulate that?
The assault...
You're referring to the second sentence of the second paragraph of the A and B instruction. You've referred to the part that says a person intends to touch another person if he does it on purpose as opposed to accidentally.
Yes.
And you state that that's insufficient. But the prior sentence says, the Commonwealth must prove beyond a reasonable doubt that defendant, quote, intended to commit the touching in the sense that he consciously and deliberately intended the touching to occur. So if the jury bought his testimony, they couldn't have found him guilty under this instruction.
Your position, Your Honor, is that the assault and
I don't have a
battery-
position.
Your argument that you've made.
I'm
or
not
your
making
statement.
an argument either. I'm asking a question and making a point from the transcript of the instructions. But
I
go
would
ahead.
agree that the model instruction for assault and battery does essentially say that an individual has to consciously and intentionally perform an act. I guess the question I would ask is, if the assault and battery instruction is sufficient in those cases where a defendant raises defense of accident, then why is there an accident instruction? Would there ever be an accident instruction in an assault and battery case?
We don't have that case in front of us right now, so I don't know the answer to that.
Well,
The question becomes whether or not this instruction, as given, captures the essence of accident.
if this instruction captures incidents of accident and sufficiently informs a jury
In this case.
in this, well, if the evidence was sufficient to raise accident, then it would be any case that is sufficient to raise accident would bear the question, is the assault and battery instruction sufficient? I don't see there being cases with a fact pattern where a defendant would raise accident, where the assault and battery instruction would not be sufficient, that an accident instruction would be required. If accident is fairly raised, then the accident instruction is required unless the assault and battery instruction is sufficient to apprise the jury of its obligations. I can't think of a case that would be differentiated where we can say, under what circumstances
What's
should
your very best published case for the proposition that the failure to give an accident instruction constituted a substantial risk of a miscarriage of justice?
I don't have one. Using the brief time I have left, I'll very quickly touch upon issue number 2, dealing with the redaction of the words pushed from the victim's medical records. They appear at 4 places: pushed off a low deck, pushed off a porch. The first issue, of course, is whether it's preserved. I don't believe this court's decision is going to turn on whether it applies prejudicial or substantial risk. The Commonwealth argues that it's not preserved. Defense or appellate counsel in his brief argues that it is preserved. The motion that was filed in Record Appendix 18 is vague, doesn't mention the medical records at all.
Don't we need to understand whether pushing is relevant to treatment?
That is true. So
How do we know that? How are we supposed to figure that out?
So one question is the burden of persuasion. Does the Commonwealth have to establish by any preponderance of evidence, clear and convincing evidence, that the statement in the medical record is directly linked to the medical treatment received? I thoroughly reviewed these medical records, and this individual had a history of a leg injury and was treated for a leg injury. Whether he fell or whether he was pushed is, from the medical records, without extraneous information, pretty irrelevant.
I mean, you're telling me something I just don't know anything about. Maybe it's different if someone flies through the air and hits the ground than if they, tumble down. I mean, I literally have no idea.
I did not go to medical school, Your Honor, so I do not know if this medical treatment would have been different if he fell or
Might not
was
even have
pushed.
been different. The question, were they pushed, or the information where they pushed, has to be pertinent to diagnosis or
It
treatment.
does.
It may be that at the end of the day, looking at the full picture, they're like, well, it doesn't matter, we're just going to put a Band-Aid on this guy, or, whatever. But if it's a relevant part of it, then it can come in, without redaction.
That's the law. I would like to make one comment on the law. The last 15 words of the statute, 23379, says, "Nothing in the record shall be admissible as evidence which references the question of liability." And there are dozens of cases going back to the 70s. And Commonwealth v. Dubé is a 1992 case. It's not a special case or a particularly important case, but I think it sums up the Supreme Judicial Court's treatment of this statute. And it says, "This construction of the statute has been called a liberal interpretation. In application, this liberal construction has permitted the admission in evidence of statements in hospital records bearing on criminal culpability that seem to relate at most incidentally to medical treatment." That is not consistent with "nothing in the record shall be admissible as evidence which references the
But that's
question
an
of liability."
SJC decision?
That's 50 years of SJC jurisprudence.
Well, you should talk to them about it. We have to apply it, right?
Well, also, counsel, though, what do you say to the fact that the kicked was not redacted out of the medical records either, right?
that's-
And the jury acquitted
Yeah.
the defendant of the ABDW?
Unfortunately, I did anticipate that question, and unfortunately, I was not able to come up with an answer for you. It is true that the kicked and pushed were in the record. He was acquitted of kicked, convicted of pushed. My review of the record and my experience with juries is there was evidence that a third party, the victim's son, came in at that point, and there was kind of a melee, and the victim's son was charged. So maybe the jury thought that it was not clear-cut what was going on at that point, so they acquitted, but they believed the victim when he said he was pushed off the...
The SJC case you just cited to us, I didn't see that cited in your brief.
It is not in the...
What's the cite on the case,
The
please?
citation of Commonwealth v. Dubé is 413 Mass 570.
570?
Yes, Your Honor.
Thank you.
Your time has expired, but if there are further questions, I see none. So thank you very much, and we will hear now from, strangely enough, Attorney Gauthier again.
No relation, Your Honor. Good morning. May it please the Court. Stacey Gauthier for the Commonwealth. It is our position that the defendant's conviction should be affirmed here. First, it's our position that the defendant did not meet his burden to show that his trial counsel committed ineffective assistance of counsel when he failed to request an accident instruction. First, again, there was no motion for a new trial filed in this case, and that's the preferred method for raising a claim of ineffective assistance. We have no affidavit from trial counsel as to why he chose to request an instruction on self-defense and not a specific instruction on accident. And we know without a motion for a new trial, the claim must appear indisputably on the record. And again, I would suggest that this does not appear indisputably on the record because we don't know why he chose to focus on what he focused on. At the beginning of the trial, he told the judge, depending on how the evidence would come in, he was either going to ask for a self-defense or an accident instruction. Then after the close of all the evidence during a charge conference, at that point, he said to the judge that he thought that the assault and battery instruction covered or encompassed accident, and the judge agreed, and so he said, well, then I guess that will encompass that. And then he went on to focus on self-defense.
Was there any evidence of self-defense? I understand there was at the bottom of the stairs. And in fact, an acquittal was obtained on the bottom of the stairs event. Was there any evidence of self-defense in the top of the stairs one, or did the lawyer just make no argument applicable to the top of the stairs?
His focus when he was asking the judge to give the self-defense instruction, he focused on what happened on the ground. And then the judge was like, oh, I don't think that's really self-defense. But then the next day, it was the judge who came back and said, well, I think in the light most favorable to the defendant, at the top of the stairs, he testified the victim grabbed him and he knocked his hand out of the way. So the judge found that at least with the low bar and the light most favorable to the defendant, that was appropriate.
So you think he knocked his hand out of the way?
Well, Your Honor, I know you had asked my brother, and I don't have the transcript with me. I can just say that quoting from him in my statement of facts, he had claimed that the victim grabbed his shoulder, and then the defendant's testimony was, I went like this with my left hand. I went up like, oh, what are you doing? And obviously, we don't know what, nobody said, well, for the record, he moved his hand. So it's unclear what exactly he did. I don't think that, my memory is that he never testified that, oh, I went like that, and that caused him to fall down the stairs. I think he just said, oh, I moved my arm, and then he fell down the stairs.
The record hasn't been reconstructed, though, to demonstrate one way or another.
That is correct, Your Honor. And I would suggest also, as far as whether the claim is indisputably on the record, the defendant in his brief even acknowledges in a couple of places that, we don't know why counsel made the decisions that he did. In the, defendant's brief, he had stated that the trial judge tried to dissuade the defense counsel from asking for self-defense, but for unclear reasons, he insisted. And then also, he stated in his brief that there was no explanation as to how self-defense was a realistic strategy. So I would suggest on that, it's clear that we don't know why he made the decisions he did without a motion for a new trial. And I would suggest, likely he didn't ask for a specific instruction because he felt that, and it did in fact, the accident instruction incorporated into assault and battery did cover accident.
If my lawyer went with that instead of the powerful accident instruction, I'd sue him for malpractice. Wouldn't you?
I mean, I don't think so. I think that it.
You don't think so? So you would be content if an accident happened and you were charged with assault and battery, just having this word accidental used, when there's a whole instruction about proving beyond a reasonable doubt that it's not an accident?
Well,
I don't think you'd be content with that.
Well,
I hope.
I mean, so it's not just, it's the three words, but what the judge says was, the Commonwealth must prove beyond a reasonable doubt that the defendant intended to commit the touching in the sense that he consciously and deliberately intended the touching to occur. So if it's an accident, right?
Of course, I understand that logically that covers it if someone is a very smart lawyer who can parse each word. But we do have this instruction that cries out, the Commonwealth must prove beyond a reasonable doubt it's not an accident. And I think any defendant who had a case for accident would be quite ill-served by someone not asking for the one that says, hey, jury, don't miss this point that's buried in this other language.
I mean, she did also give the beyond a reasonable doubt instruction as well. But again, we don't know why he chose to focus on self-defense and not accident without an affidavit. So I would suggest that the defendant hasn't made his burden to show that trial counsel committed ineffective assistance of counsel. And if there's no further questions, with regard to the issue number 2, I would suggest that the trial judge did not abuse her discretion in declining to redact the word pushed from the medical records. Again, as stated in the brief, in the day leading up to the judge's decision on the redaction of the records, the defendant's counsel focused his argument really on the kick, right? And at one point he even said, I certainly would not object to the pushing down the stairs because, I wouldn't object to that. It's the kicking, so I would suggest that this is not even preserved. However,
why wouldn't he object to the pushing down the stairs? Well, again, you would have.
I
would have. Right? Why be telling them push 4 times in a medical record?
I don't know. But again, we don't have an affidavit to ask him. But in any event, so even if he did in fact object to the push, I would suggest that the statement was properly admitted as a statement made for medical treatment. I had cited some cases in my brief. One of them was Commonwealth versus McGann, where the court found that repeatedly beat him about the head and face and bit him several times in the arm fell within the exception because it related to, bite marks, and it was a fact-specific reference to the reported cause of the accident. And so here, I would suggest that the victim telling the doctors that he was pushed was a fact-specific reference to the cause of his accidents because, a push, I would suggest, would maybe be like, falling as a result of being pushed, I would suggest, would be a different level of force than just, say, if you missed a step and fell. So I would suggest. How are we
supposed to resolve that question?
Well,
Right, I don't have the first idea whether being pushed and falling are relevant, that difference is relevant to diagnosis. I can see just what you said. Yeah, maybe. Or maybe totally not. I just have no idea. And we all sit around and go like, oh, pertinent to diagnosis and treatment. But no one comes in and tells us, how are we supposed to figure that out?
Well, I would say, I think you just have to look at the test. In a case like this.
Well, I'd like a medical person to provide some insight. I mean, is that what a defendant has to do to get something redacted? Or is redaction the presumption and the Commonwealth has to say, no, it's for diagnosis? Like, how does that work?
Well, I mean, I believe, the law says that the statute is liberally applied, so I think that it would be relevant and that it would come in unless it goes specifically to liability. So I don't think that you would need a doctor.
I don't know why we're calling that liberally applied. I would think liberally applied would mean, so black everything out. And this rule doesn't say black everything
No,
out at all.
I think it's the opposite.
It says, yes, I do
yes.
too. I think it's being read narrowly, right? To
Right,
allow
so-
in a lot of stuff if it's pertinent to diagnosis and treatment.
And so I think that we err on the side of that it is under the case law, and then keep it out if it goes to, liability. And I think, the cases say, even if it touches on the question of liability, it's admissible. So I think that it would be admissible in this case. However, even if you find that it wasn't and that it shouldn't have come in, I would suggest that there was no prejudice because it's cumulative to the victim's testimony that he was pushed and kicked, and cumulative evidence is.
Yeah, but the reason we leave out medical records is they have a certain imprimatur. They might imply, even if they're just recounting what someone said, that doctors believed that person, or it might even imply that doctors concluded somehow that the person was pushed. I mean, we see this mostly in sexual assault cases. In fact, I'm trying to think if I've ever seen one outside that context, but that's so it's not quite cumulative of someone else saying push.
I mean, in the sense that I don't think that it's the doctor's, medical, I think it's what the records say is that patient says he was pushed and kicked. I don't think that it's a finding by the doctor that he was pushed. So I think that goes with the cumulative testimony. I don't think, that's my thought on that. But again, even on top of that, if it shouldn't have come in, kicked also came in, and the defendant was found not guilty on the charge that related to the kick. So I would suggest, there was no prejudice. The jury wasn't swayed by any, medical records that said he was kicked when they found him not guilty of that charge. And if there's no further questions, I will rest on my brief for anything not addressed.
I just have a comment. That's Attorney Gauthier, Mr. Gauthier. That's I indicated to you that, or I asked you whether or not that case was included in your brief. You said it was not, but for the record, you are successor counsel and you inherited this brief, correct?
Yes, Your Honor.
Okay, I just wanted to make sure the record reflected
Prior
that.
counsel had a medical issue,
Yep.
so I stepped in.
But it's not, you didn't draft the brief.
I did.
Very good, thank you.
Thank you.
Seeing no further questions, the case is submitted. Thank you both for excellent arguments. The next matter we will hear is number 24440. This is Commonwealth versus Roman. And we will hear first from Attorney Methe, whose name I have probably ruined, but you'll
That's
let me
fine,
know.
Judge. That's Methe. May it please the Court, my name is Attorney James Methe. I represent David Roman in this appeal. I'm going to argue the second issue in my brief first this morning, and that is that the judge committed prejudicial error when she denied a defense counsel's motion for a mistrial based on the prosecutor's opening statement. There was a motion in limine decided prior to the trial. It indicated that there could be no reference to why the police were near my client's house at the time, and they could only say, it could only be adduced that it was related to an unrelated investigation. So the prosecutor in his opening statement, which I would point out is quite short, it's 3 pages of the transcript, violated that motion in limine several times. And I'm going to read what he said just so I have it accurately. One of the first things he said was, quote, "Police were conducting surveillance outside this defendant's house." Shortly after that, he said, quote, "Police arrested him for a warrant." And later on, he said the officer was surveilling the defendant's house for unnamed reasons, and also he's looking for the defendant. So he completely ignored the motion in limine. It's really the first thing that obviously the jury heard because he went first, the opening statement was first. So he put in the jurors' minds right from the get-go that my client had some type of criminal history. Now the judge addressed it sua sponte after the openings of both counsel, mainly to talk to the prosecutor about what he couldn't get from Officer Bernat, who was the first witness, that, you know, why they were at the house for some other reason, or there was there for a warrant, or just warning the prosecutor what he couldn't do with the witness. The next morning, the judge again, sua sponte, addressed it, obviously concerned about this opening statement, and the parties discussed it and agreed on a stipulation that was read to the jury at that time and was read to the jury in the closing argument, and the stipulation was, I'm going to quote that also, "The police were outside the defendant's home on an unrelated investigation. You should not draw any negative inference against the defendant based on that fact." I would argue, though, the stipulation didn't cure the problem because the stipulation was the next day. So the jury had an entire day to think about what the prosecutor had said in his opening statement. In addition to that, the prosecutor made a false statement of fact, and that was the first sentence of his opening statement when he said, quote, "They saw him leave the house carrying this firearm." I'm assuming that's when he picked up the firearm. "Carrying this firearm that was inside a camouflage bag you'll see, as well as some drugs."
Right, carrying this firearm that was inside of this bag, how is that a misrepresentation?
Well, because I think the way it's worded is that the police actually saw him carrying the firearm.
That's not what he said. He didn't say that they saw the firearm. He said carrying the firearm within this bag. They then go into the trunk, and in the bag is the firearm.
Well,
I don't see how that's misleading.
I would argue that it is misleading because of the way he worded it, because he said they saw him carrying this firearm.
In this bag.
Well, the way I take it to be worded is that it could have been worded.
There might be an implication that they knew that firearm was in the bag as he was carrying it. That's how they knew he was carrying it. That they had seen, somehow, they couldn't see it while it was in the bag, but they saw him carrying the firearm in the bag. I mean, they didn't see him, I mean, they saw him carrying the bag. They didn't see the firearm, and it does have an implication that they knew there was a firearm in it or had seen him put the firearm in it or something, maybe. Maybe.
I would argue I'm actually more concerned about the prior statements.
And let's get back to that. How do you show prejudice in this case?
Well, as I said, because the fact that even though there was a stipulation the counsel agreed to, the stipulation came the next day because the judge was so concerned about the prosecutor's opening statement. And I think the jury...
Would your position be different if the judge had given it right after the opening statement? Would that make a difference to you?
Well, it would have been better if he had done it, if she had done it right after, yes.
Does it cure the problem with arrested on a warrant?
Pardon me, Your Honor, what was that?
Does the stipulation cure the error of the prosecutor saying that the defendant was arrested on a warrant?
No, I don't think it cures the error, Judge, because I pointed out, saying he's arrested for a warrant puts in the minds of the jurors that he's got to have some kind of criminal history. So I don't think it cures that particular statement, no.
Did the defense contest the element of possession of the firearm in this case? My reading of the closing argument is that they did not. Their defense hinged on whether or not the Commonwealth presented sufficient evidence of an absence of a license to carry. That's what was repeatedly argued in closing, and that seemed to be the sole defense to that charge.
Well, there was also arguments about the drug charge, which he ended up being found not guilty.
She was acquitted on, right.
I think you're right, Your Honor. The main defense regarding the gun was about the witness who testified. I don't recall exactly what the closing argument was at the moment, but.
And you just brought up that the jury acquitted the defendant of the drug charges. Isn't part of the concern here that the jury would have been so overwhelmed by the quote-unquote inappropriate argument that they weren't able to do their function and their duty? And doesn't the acquittal on that count at least tend to suggest otherwise?
Well, I would suggest that the reason they found my client not guilty on the drug charge was because the analyst said there were 2.4 ounces of marijuana in the car, and there was no testimony by the drug expert that it was consistent with distribution. So that's what I would argue is why they found him not guilty on the drug charge. It has nothing to do with the prejudice from this opening statement. I will move on to the other issue in my brief was that the judge abused his discretion by allowing the witness from the DCGIS to testify that he ran a record and there was no record and my client had a license to carry. Concerning this issue, I'm aware that the Supreme Judicial Court has recently heard argument on this particular issue in the case of Commonwealth versus Smith.
So should we hold this case for Smith?
Well, Your Honor, it's up to you. My client is not incarcerated, so if you, I suppose, took a little bit longer to decide the case, it's not going to.
But do you think that Smith will answer this question?
Well, I believe so, because it was definitely an issue in the brief that was presented and was argued. I listened to the argument, so it should be decided.
Was it directly on point?
Yes. There were 4 issues in Smith. It was the 4th issue in the brief, and that's been argued in front of the court.
And I'm sorry, I just don't know. What date was that argued?
March 3rd.
Thank you.
Obviously, no decision yet. So, in this case, an employee of the DCJIS testified that he ran my client's name and date of birth and found no record that he had a license to carry. I would argue this is not the person who should be testifying to this, that it should be somebody from the Firearm Records Bureau and not somebody who can just run a record check a few days before the trial.
There is a federal, an exception in the federal rules for absence of a public record.
Right.
So, and I think we have in Massachusetts something
Yes.
equivalent.
Yes.
Why doesn't that cover this?
Well, because I'm arguing that he's not the proper person to be testifying, so therefore.
I don't know what that means. Improper why? If it's hearsay, but it's in an exception, then the person who knows the hearsay, heard the hearsay can.
Well, I don't think, as I said, that he can testify as to any, he should have been excluded from testifying altogether because not being the proper person to be testifying. So that's my argument, that.
And he's not proper under what? What's the legal?
I'm arguing that he's not the proper person because, well, basically, to get into my argument a little bit more, Judge Lowy in his concurrence in Guardado talks about that really the person who testifies in this regard should be somebody from the Firearm Records Bureau or a police officer. And here we have a person who is apparently employed by DCGIS and testifying he ran a record check a few days before the trial and came back with no record found.
How is that any different from what a police officer would testify to? I ran a record check and didn't find anything.
I understand.
Wasn't there adequate foundation laid in terms of the witness who did testify? There's no requirement that it has to be a custodian, right, or keeper of records. This witness testified that he was familiar with the records of CJIS, he had access to them, he knew how to search them, knew how to find out how they were created and maintained, right?
Well, not maintained. Another part of my argument is that even though this person testified how, on the voir dire, how the records are created and how he accessed it, he didn't testify about how they're maintained. And
But there's still sufficient foundation laid, right?
Well,
for him
I
to
would
be able
argue
to
it wasn't
testify?
sufficient foundation laid, because, again, in Justice Lowy's concurrence in Guardado, he talks about the person that's going to testify about the absence of a public record. The witness must be familiar with how the record was created, maintained, and accessed. And this witness, on cross-examination, said he had nothing to do with the maintenance of the records. So that's why I'm arguing he's not the proper person to be testifying about this. Justice Lowy also said the contents of computer-stored records, which these are, I would argue, may be hearsay unless the records are properly certified. When there were no certified records here, there was no documents introduced into evidence, just the witness's testimony.
In this case, wouldn't you have to certify all the records in the thing? And then say, look, here they all are, and none of them has the defendant on them. How would you do that?
Well, I don't know exactly how you would do it, Your Honor, but that's not up to me. But I think a document could be presented that the records were run and his name didn't appear as having a license to carry, and have it certified by the Firearm Records Bureau, because they're the ones who actually received the applications from the local police department. As the witness testified on voir dire, they received the applications from the local police department. They actually issued a license, sent it back to the police department. And my client was prejudiced by this employee's testimony because there was no other evidence that he didn't have a license to carry.
Can I ask you about the prosecutor holding up the gun? Because you say it was improper, and the Commonwealth says maybe permission should have been sought, but there's no rule about that. It's not improper to show evidence.
I'm not overly concerned about that. I know that the trial counsel objected to it, but it ended up coming into evidence. I think maybe there was more concern, well, because it hadn't been introduced into evidence yet, and maybe there were some safety concerns also, but I'm not overly concerned about that today. If there's no further questions, I ask you to reverse the judgments.
Thank you.
Thank you.
Thank you very much. We will hear next from Attorney Kennedy.
May it please the Court, Ann Kennedy for the Commonwealth of Massachusetts. Good morning, Your Honors. I would like to start with the first issue first because I think I can clarify something, particularly with respect to the case that the Supreme Judicial Court just heard on this very issue. Legally, this case is right on point. I know this for a fact because it was my colleague who actually argued the case before the SJC. They are going to address, particularly with respect to when a deciduous employee simply testifies, there was no certificate or BOP-FI introduced in this case, when they testify, whether that testimony potentially violates the hearsay rule and whether or not it violates the Confrontation Clause.
Is the Confrontation Clause question at issue here?
The Confrontation Clause question was raised in this case, and it is at issue in this matter. And the Commonwealth, the Confrontation Clause was not violated here.
What's your position on why not?
Oh, the Confrontation Clause was not violated because the person who conducted the search, who was familiar, who testified at the voir dire, that they were familiar with how the records were created, maintained, and stored, testified to that effect and was available for cross-examination.
So you think it is testimonial hearsay?
I think his testimony is testimonial hearsay. The BOP-FI itself, I would argue, is not testimonial, which is what my counsel was arguing.
His testimony isn't hearsay at all. It's testimony.
That's what I meant. I apologize, Your Honor.
Okay, but so you say the hearsay isn't testimonial hearsay, then what do we care about the knowledge of anyone of anything?
I apologize. I just misspoke.
Okay.
That with respect to the Confrontation Clause, The person who testified, the deceased employee, was given his background, given the voir dire, was the person who conducted the search. He is the person that should have testified, and as such, the confrontation clause was not violated.
So you do not say that it is not testimonial hearsay. Your position is it is testimonial hearsay, but it was presented by the proper person.
And hearsay in that, two things, Your Honor. First of all, with respect to that, it was admissible hearsay because it's an exception to the hearsay rule.
Yeah, but the confrontation clause doesn't care about that.
Exactly, but you have to first assess whether or not the hearsay was admissible, and then you assess whether or not the confrontation clause was violated. What my counsel brought up was with respect to the certifications and BOP 5s, whether or not those would also be deemed hearsay. And it's the Commonwealth's position that those would not be deemed hearsay. Those are not computer stored, they're computer generated, particularly because in this case it involved the lack of a record, not the existence of a record.
I'm sorry, I don't understand what that latter thing has to do with the confrontation clause. You say it's not.
Because with respect to the computer generated, if we had introduced the BOP 5, there's two aspects of hearsay involved there, correct? There's the testimony of the witness, that's one aspect, and then there is the actual document. And would the admissibility of the document itself violate the confrontation clause, which Justice Lowy did address in his concurrence. So what I am saying is, contrary to what counsel is saying, had that been introduced, it would not have violated the confrontation clause because it was not testimonial.
And is it your view that Smith will address both of these issues, confrontation clause and admissibility as hearsay?
Yes, Your Honor, it will.
Okay.
So Smith involves Crawford, Melendez-Diaz, and basically the same issues that were involved in the, I can't remember the name of it, but the drug certification case?
Yes, Your Honor. Yes, Your Honor. And in that, it's the same circumstances in that the person in our case who conducted the search was the person who testified. Quentin Smith is the exact same scenario. Facts are a little bit different, but in terms of what the extent of their foundational knowledge, but other than that, legally it is on point, and it will be.
Can you address the other issue, the prosecutor's opening in the motion for mistrial?
Yes, Your Honor. With respect to that, I think it's important to read the motion in limine and to read the judge's decision on that. The judge stated that there may not be any reference to the call by Cara Jolie. Cara Jolie was a person who actually called on the defendant with respect to brandishing a gun in front of her. None of that testimony came in. Or the reasons that the police were investigating the defendant at the time. The Commonwealth will be limited to testimony that the police conducted an unrelated investigation when observations of the defendant were made.
Yes, that's what they're saying was violated.
Exactly. And I think the reason why it's important to understand the entire position is when you read the prosecutor's opening statement in whole, he was trying to avoid the issues raised by the motion.
I don't care what he was trying to do. He was allowed to say there was an unrelated investigation going on, and they saw so-and-so come out with the backpack and put, okay. And instead he says they're surveilling his house and looking for him, and he's arrested on a warrant. So that goes beyond the scope of an unrelated investigation.
Yes.
Okay.
I will concede that point. What I am trying to show is that it wasn't in the prosecutor's eyes and neither in the judge's,
No one
a
is doing
deliberate
anything to the
violation.
prosecutor, right? There's no ethical proceeding going on. The question is just, was this improper and did the stipulation cure any impropriety? I think that's the question.
Well, one of the issues that counsel raises in his brief is that the prosecutor acted in bad faith. And what I am trying to argue before this court is that the evidence as set forth in the opening statement and in the conversation shows that that was not the case.
I don't know that that's clear, but let's leave that bad faith question to the side for a moment.
Certainly.
The judge didn't find bad faith, or did he?
No, she did not. The
Okay.
judge did not find bad faith. The judge did call up the attorneys after both openings, and sua sponte brought up the issue that was raised. Counsel had not recognized it as such until she brought it up, and at that point asked for a mistrial. She stated on the first day that she wanted to see how the testimony went before, and let's see how we advance. This is a little too early to ask for that. At that point, she instructed the prosecutor to talk to the witness that was already on the stand about what that witness, the police officer, could and could not testify to. So they took a break. At that point, it's clear.
There was a motion for a mistrial when this happened, right?
There was not a motion for a mistrial till after the judge sua sponte raised it.
Next day?
No, the first
Right
day.
then, yes.
After the opening
Okay, and
statements.
there was a motion for a mistrial.
There was a motion for a mistrial.
Why do you say that shouldn't have been allowed?
Because at that point, he had asked for a motion for a mistrial. She denied it and said, let's see how it goes.
Why isn't that an error?
Of the judge, why didn't she abuse her discretion at that point?
Why was she not required to declare a mistrial?
Because at that point, there was nothing to suggest that the jury would have been so prejudiced as to require her to declare a mistrial without thinking of different ways to obviate that. And the first,
There was no
if I may.
discussion of obviation right then.
Yes, there was, Your Honor. That's the issue, is at that point, she came up and told the prosecutor what could and could not come out in evidence. She also asked the prosecutor to speak to the witness who was testifying and asked to be sure that, and this was the police officer, that nothing regarding surveillance, that they were investigating the defendant, or that there was a warrant should come out.
Okay,
He then.
But you're not exactly answering my question. A prosecutor during opening says, the defendant here who's charged with a crime today had an open warrant for his arrest, and the police were surveilling him and looking for him. So now a jury hears that there's a past criminal history. None of that stuff, of course, can come in at trial, right? That's past bad acts, propensity evidence. It's impermissible. But the prosecutor says it.
Yes.
Why doesn't that require a mistrial?
It doesn't automatically require a mistrial.
Why?
Because there are ways to obviate that. And that is what the judge was doing throughout the trial.
How do you obviate that?
The way the trial judge did.
A day later, you force a stipulation on the parties.
It wasn't a forced stipulation on the parties.
Mm-hmm.
This was a stipulation that the parties helped craft, particularly the defense counsel, who added information pertaining to it.
The defense counsel also said, when asked if it should be corrected, said, I've already asked for a mistrial.
Yes.
So it is clear that they weren't saying, but this will do. They're asking again for a mistrial. But I'm still trying to figure out, okay, so they enter stipulation. Why is it okay that it's a day later?
Well, with respect to that, given that, if I can now explain what happened on the first day, where she explained to the prosecutor what he could and could not do, told the prosecutor that you can only ask, particularly with respect to an unrelated investigation, allowed the prosecutor to do that. The next day, before the testimony continued, she asked the counsel if that obviated it. At that point, the counsel said no. He did not believe that that was sufficient and again asked for a mistrial. She then suggested that they craft a stipulation together, which they did, that she would read to the jury as an instruction.
And how did it obviate? I mean, first of all, it's a day later. I don't know. I'd have to look at the full transcript of the first day. The jury's sitting there all day the first day. The defendant's right there, and they have every reason to think he's a criminal because they were told that by the prosecutor. So I'm not in love with that. But even with this stipulation, they said he was arrested on a warrant. The stipulation doesn't undo that.
The stipulation might not have undone the warrant piece, but the question becomes, Your Honor, that the jury clearly wasn't prejudiced by this. They acquitted him of one of the charges. And if they believed that, if they were swayed by his criminal intent and his criminality, why did they acquit him of that charge? And that is something that the case law requires that we look at to determine whether or not the judge abused her discretion when she refused to declare a mistrial. Additionally, after creating the stipulation with the defendant and after deciding that they were going to state, which he had already stated before, that opening statements were not evidence, again saying that, she asked the defendant if he was satisfied. The defense counsel said yes.
Having asked for a mistrial twice. I mean, once it, I don't think that's, have I undone your mistrial motion? Are you now happy that I didn't allow it?
I actually think that that is what the case law allows the judge to do. The case law, if you look at Commonwealth versus Beaudry.
I'm just saying it's not waived by the counsel saying at the end, yes, I'm satisfied, Your Honor, when there have been rulings against. That's not a way of saying, and I didn't mean my prior objections.
Your Honor, I have to say in Commonwealth versus Beaudry, where the defendant, where there were objections to the prosecutor's closing arguments, and the judge crafted particular instructions with respect to that, and asked the defendant if he was satisfied, and the defense counsel said yes, that was waived. That was a substantial risk of a miscarriage of justice. It was not something that suggested otherwise, and I've seen counsel before, many a time, have no problem after the judge crafts out remedies saying, note my objection, I am still asking for a mistrial, as opposed to saying he was satisfied with it. If there are no further questions.
Well, your time has expired also, so thank you very much.
Thank you.
Very helpful arguments for us, and the case is submitted. We will take our traditional mid-morning break and we'll return in 10 to 15 minutes to hear the remaining two cases.
Mr. Sessions, please be seated.
Welcome back. Good morning. Our next matter, if I can figure out what our next matter is John Doe 527557 versus Sex Offender Registry Board, number 24307. I'll remind you all that this is an impounded case, so we're going to use Doe, not names, and if there are other names, we're not going to use those either. We will hear first from Attorney Gauthier.
Good morning again, Your Honors. May it please the Court. My name is Edward Gauthier. I'm arguing today on behalf of John Doe. John Doe was finally classified as a moderate risk level 2 sex offender by the Sex Offender Registry Board. Mr. Doe has a prior history of 7 sex offenses, 2 indecent exposure, 5 open and gross lewdness. We make 4 arguments. The first is that the evidence was insufficient. There was not substantial evidence introduced at the hearing on the issue of degree of danger. We do concede that Doe poses at least a moderate risk of reoffense. We do not believe the facts in the case law from the Supreme Judicial Court justify a finding that he poses a moderate degree of danger. As the SJC has found, when a hearing examiner finds that all the prior offenses are non-contact sex offenses, there must be evidence and a finding of a likelihood of putting people in fear of a contact sex offense to justify anything higher than a level 1. In this case, the hearing examiner thwarted Doe's every effort to show that he is among a class of offenders who poses the lowest risk of committing a contact sex offense. Now, the fact that the hearing examiner found that Doe's risk of reoffending is moderate and degree of dangerousness is moderate speaks to the arbitrary and capricious nature of their findings. I think it's pretty clear from the evidence that my client's risk of reoffense far exceeds the danger he presents to the community. In terms of factual comparison, there are 2 cases in the record, one from the SJC and one unreported case from a panel of this court. And when you have sex offender cases before the board, they always run the gamut from the worst to the least bad. And it's the job of the board and this court on review to kind of figure out where the doe lives. So in 496501, the SJC found that a level 2 finding was not warranted based on the evidence of non-contact sexual offending.
Can I ask you, the facts in that case, can they be distinguished from the facts here? The facts in that case, right, the offender in that case, both of his offenses, first of all, were fewer. There were only, I believe, 2, right? And they happened in his home, right, in front of a window. And the teenage neighbor, I believe, was the victim in that case. And here, your client, almost all of his, I believe all of his are in public, right?
All 7, yes, Your Honor.
With strangers, and the victims are different ages and whatnot.
Yes, as I said, each of these cases runs on a continuum. The interesting thing about sex offender registry board cases are no 2 cases are exactly alike. So on 496501, you do have fewer incidents. Our argument would be that the number of incidents goes more to the risk of reoffending. And again, we agree because Doe has 7 prior offenses. He has a possibly astronomically high level of reoffense. But looking at the actual sexual offending, comparing it to KM, in KM, this individual had a juvenile record of violence. He had a history of breaking and entering, abuse prevention order violations, aggressive sexual offending. He was essentially a stalker, a predator. He was pretty extreme when it comes to non-contact sex offenses. In this case, Doe has no history of non-sexual violence, no history of restraining orders, no history of criminal harassment prevention orders. His history is when he goes into public places, he loses his pants. Where is it between the SJC case and the KM case? It's somewhere in the middle. Which side does it fall on? We argue that it falls on the side where there's simply no justification with the evidence in the hearing examiner's findings of fact and application of regulatory factors that it falls on the side where a level 2 is required. I would like to address two arguments together because they go together, and that is the thwarting by the hearing examiner of Doe's attempts to introduce science into the proceeding. The board has 38 regulatory factors, 6 are statutory, 32 are by regulation. These factors don't typically directly deal with people who have a history solely of non-contact sex offenses. So Doe tried to introduce a research article which shows that non-contact offenders who have no history of criminal offenses beyond non-contact sexual offending and no history of abuse prevention orders have a chance of escalating to a contact sex offense of 5 to 10%. The hearing examiner said, I don't care. The board's duty is to assess the risk to offend generally, not specifically to contact sex offenses. And although he finds it interesting, he doesn't give this article any weight. Well, the SJC has already said that in assessing a non-contact sexual offender, the board has to assess the likelihood of either engaging in a contact sex offense or engaging in a non-contact sex offense that's likely to put an individual in fear of contact.
Did the hearing examiner do that here?
The hearing examiner did not did not make any findings regarding the chances or the likelihood of a contact sex offense. The finding was that Doe poses a moderate risk of reoffense and moderate degree of danger.
So where the judge does not address that issue, the likelihood of placing a victim in reasonable apprehension of a contact offense, is the correct result to remand to the hearing examiner to address that issue explicitly?
That could be an answer, unless this court finds that the evidence is just plainly insubstantial. Then
What evidence is there that could support that?
There's no evidence in the record at all, in my mind, to suggest that Doe is at a risk of a contact.
Did they ask any of these victims if they felt that they were at risk of contact?
The victims don't appear before the board. They rely solely on the police reports.
Did any of them say anything about fear of a contact offense?
No, some were shocked, some were alarmed, some were justifiably grossed out.
That supports the elements of the underlying charge, right?
Yes. Alarm, shock for open and gross is an element. And they were plainly offended, grossed out, but there was no evidence that anybody had any fear that they were going to be touched.
And we would have to find that there was sufficient evidence for finding by clear and convincing evidence.
That is correct, Your Honor. That's the standard from the SJC. For all of the elements, 3 elements, risk, danger, and that the internet publication or public dissemination of biographical information is warranted.
And am I correct that that can't be ordered in a level 1 finding?
Yes, Your Honor. Only level 2s and level 3s are posted on the internet. Level 3s have the addition of what's called community-wide notification, which could be something like posting pictures on telephone poles. You can't do that for a level 2. But since the law changed in 2013, in our clients' minds, level 2s and 3s are almost the same because of the internet dissemination. So you have not...
So I'm sorry to interrupt,
yes,
but let's get back to this notion of, whether or not it's likely to place a victim in reasonable apprehension of a contact offense. The hearing examiner here seemed to be concerned with what I would call an escalation.
Yes.
And the best example, I think, would be the 2019 offense where your client was in a public library, I believe, and walked up toward or was in sight of a 15-year-old girl,
yes.
And he exposed himself and started masturbating, doing what it is that he has a proclivity to do. The hearing examiner, I think, made a finding, or at least alluded to the notion that this has been escalating behavior, it's arguably happening more frequently, and it's happening in more public places. What do we do with that? I guess my question is really twofold. Number one, why is that not enough? And number two, what would it take in a non-contact offense context for there to be a proper level 2 determination?
First, I would just point out that all 7 offenses were in public places. and 6 of the 7 involve a specific individual that he was directing, I guess, for lack of a better word, his attentions. In terms of, under the SJC ruling, there should be a finding. I mean, the board is very well aware of SJC precedent. There should be a finding. I find that given the escalation of the behavior, there is a likelihood of a contact sex offense or reasonable apprehension. There was no finding of that here. And the offenses don't really escalate much. If you look back to 2004, Doe exposed himself in a library to a 50-year-old librarian, and he admitted that he selected his victim because he found her attractive. So his pattern of offending is really been the same since 2004. All of his 7, he identifies an individual and he touches himself. We don't take any issue with the risk of reoffense. It's just, was the evidence sufficient? And I can say the evidence would not have been sufficient if we had an expert. So we asked for an expert, and we asked to introduce scientific research studies, and the hearing examiner said no, that it's interesting, but it's not relevant to Doe. The hearing examiner found that a scientific article on the very low risk of contact sex offending among people like Doe, and an expert to come in to talk about the likelihood. These are not relevant to a determination of Doe's risk
I
of
remember
reoffense.
one case, I don't know if it's published or unpublished. If it's unpublished, I was probably on the panel because I'm not sure I would remember it in such detail. But it was a case where the risk of contact, of escalating to contact offense, was demonstrated by someone approaching someone in an elevator, which was an enclosed space where they might not be able to get away, and going to the apartment of a victim and taking a picture of his hand on the doorknob.
That's KM.
That's the KM case that was
the
cited
KM
in the Commonwealth's
unpublished.
brief.
Okay, so that showed the kind of escalation toward contact.
For sure, that KM's a predator.
Okay.
Although my client's offending is a little more extreme than the SJC example, he's not the predator that KM is. He's not going to individual people's places or workplaces and singling them out. He's finding a person in a public place and doing his business. There's only one other issue. It's the board hearing examiner found 2 high-risk factors. And high-risk factors are very, very bad for a sex offender because the statute makes clear that in the finding of a high-risk factor, the sex offender is likely to be high risk. And in this case, the hearing examiner applied factor 3, which is anytime you have an adult offender with a child victim. The Supreme Judicial Court addressed a similar case where a victim to an indecent exposure was under the age of 16, and the board applied factor 3, and the SJC said you can't because under the definitions of sex offenses and sex offenses involving children, indecent exposure is not a sex offense involving a child. Well,
What about open and gross?
open and gross lewdness in the statute is not a sex offense involving a child. So the question really is, if this was error, did it really weigh on the hearing examiner's final decision-making? And to that, all I would point out that is in the final findings in the last few pages in determining risk of reoffense, degree of danger, and the benefits and justification for internet dissemination, the hearing examiner did cite this high-risk factor.
Is this argument preserved, though?
Yeah, well, I believe that the Commonwealth does argue that prior counsel who represented Doe in the hearing stage and in Superior Court did not raise this issue. And my response to that is that's a shame, because it's a good issue. If there are no further questions from the panel, I would rest on my brief.
Thank you very much. We will hear next from Attorney Greenaway.
Good morning, Justices. Attorney Roxanne Greenaway for the board. May it please the court. First, I just wanted to double back on some facts that we were talking about. With regards to the indecent exposure and the child victim, that is for Doe 496501. those are the facts of that case, that indecent exposure took place in his home.
Can you talk into the microphone? I'm having a little...
The indecent exposure took place within his home prior.
Did it mention that at all in the decision, 496501?
I'm sorry?
Did it mention his home as the critical factor there?
In those 496501, if you go to between pages 660 and 661, that's where the court basically lays out why this particular individual was not a high-risk person. And to Justice Tan's point, I was going to distinguish that case because the facts are indeed different. There you have someone, the juvenile nature of that child is that when the indecent exposure took place within his home, she was 15 years old. As she got older, he then committed the open and gross part of his sex offending behavior. So the court indicated that you could not apply the high-risk factor adult offender with a child victim to the indecent exposure because it's not a sex offense at all. Whereas in this particular case, the victim that Mr. Doe offended against, the juvenile victim, the minor victim, was an open and gross.
Wait, I'm sorry. You're talking only about factor 3 here? Is that what we're discussing?
Don't
Yes.
you argue that
I've argued, but the court asked about it, so I didn't know if you wanted to address that.
Actually, could you focus your argument on the dangerousness issue that opposing counsels raised?
And the hearing examiner points out, in each case that comes before the board, the hearing examiners must look at which factors apply and the facts of the case and decide 3 different things. That is the risk, the danger, and the efficacy of internet dissemination. Here, he concedes, Doe concedes that the risk is moderate.
So if you can talk about the danger.
So with regards to the danger, the hearing examiner pointed out the different factors in the hearing examiner's decision that supports the dangerousness determination, and you can find that on page 23 of his decision, where he indicates the factors that are applicable are indeed factor 3, the high risk, the statutory high risk factor, factor 7, and that was applied with increased risk because he had 7 stranger victims. Factor 22 because he had, again, multiple victims. Factor 21 because he had a diverse set of victims. And then factor 13 will full risk, and then in mitigation, factor 28. And I would point out that all of the factors are specifically designed to determine a person's current risk and their current danger.
Doesn't Doe 496501 say that he has to objectively put victims in fear of a contact offense, or he has to be a level 1 if he has only non-contact offenses?
I do not agree. I do not agree with that. I think in the facts of the case, because when you look at on page 660 to 661, where the court is basically having this discussion as to why that particular Doe is not a higher risk and why they should be found, the court is very. They point out that everything occurred within the home. He has only had those sex offenses or sexual misconduct behavior within a certain period of time.
Okay, so that's fine about that person being inside. Most people who engage in these kinds of crimes don't do it inside their home, out a window that the children in that case can look into.
Well, the open and gross, I'm sorry.
But there are cases. The one in particular that I found is Commonwealth versus S.O.R.B. This is where the test about risk of fear of a non-contact offense, that's where it comes from. It's actually in the SDP context. Mm-hmm. But that's where the test comes from. And all of that person's offenses are in public. So I don't see how the public-private line that you're drawing has anything to do with fear of contact, with whether you're required to find and show by clear and convincing evidence that he is likely to put people in fear of a non-contact offense.
I don't agree that the court finds that you have to make a finding by clear and convincing evidence of that. I think
His dangerousness has to be shown by clear and convincing
Correct.
evidence. And his dangerous is not the non-contact offense, because that's not the kind of danger that the statute is concerned with. It's concerned with contact offenses.
Well, if you look, again, I think when you look at persons' risk and danger, again, you have to look at all of the applicable factors. And
I have to
go
look at
back.
the case law. I'm looking at the case law. I understand there are all these factors, but if all that's going to happen is a non-contact offense, I don't see how any of those things can raise the danger of a contact offense unless and it seems as though this hearing examiner, I don't know the various hearing examiners, but this one quite explicitly indicated that she or he didn't care about contact offense.
I do not agree with that. If you look at the hearing examiner's decision, the sentences before where the hearing examiner points out that all of his sex offenses are indeed non-contact. If you go back before that, the hearing examiners discussed what Justice Neyman discussed, that he was escalating in behavior.
He says escalating from exposing himself to
Correct.
masturbation.
Right, and that.
But in fact, every single case except one in 2004, from 2017 till 2021, every single one was masturbation. There was no change in the pattern at all during the 4 years when he had his most recent 6 offenses.
But I don't think you stop there, Your Honor, because then you have to look at the other part that the hearing examiner points out, that he is in fact committing these offenses in areas that children are designated to. And when you look at the fact in the administrative record, you're going to have that he returned to.
And so your view is that exposing yourself in a place where children are present can make you dangerous in a way that other non-contact offenders aren't.
I think you have to look at the facts of each case. And with this particular one, it's not only that he's committing his offenses in public areas and in areas where children are. Again, I point out in the record, he was within 3 to 5 feet of some of them. When you look at the child within the library, the teen in the library, she describes that she saw him looking at her previously, and then.
And therefore was in fear of a contact offense, or was just disgusted?
The police report did not say that. You can only go on what's in the record. And so I don't think it would be fair for a hearing examiner to make a leap and say that definitively that someone's going to commit a contact sex offense. But what you have the hearing examiner indicating is that he does have this escalation, there is this concern, and because of.
The only escalation mentioned, if I'm not mistaken, because I read the hearing examiner's report several days ago, but carefully, is the only escalation that the hearing examiner talks about is from exposure to masturbation.
Correct.
Doesn't say anything about smaller and smaller spaces or different kinds of victims, just the escalation. But I'm saying I don't really see he consistently for the 4 years leading up to the final offense here, it's been the same exact, different victims, same exact conduct.
Masturbating is the same conduct. However, you have him, one of the stores he's going more than once, he's returning to the area, the libraries you have him returning to the area. So this is not someone that's just going to any public place. He's returning to areas and putting people in that fear.
No, you just said there was no evidence that he put people in fear of a contact offense.
Of committing a sex offense, which is the masturbation. That is the nature of his sex offending in this record. His sexual offenses is non-contact. There is no doubt about that. His conduct is non-contact thus far. The hearing examiner is indicating with the factors that apply that indicate danger as well, which I pointed out, the statutory high-risk factor and the other ones, as well in conjunction with the fact that he is committing, it's distinguishable from DO 496-501. This is not within his home, where the court indicates that someone of that nature would not reasonably be suspected to commit another offense outside that home.
Is there some case where we don't apply 496-501 because the person is in public? Because I don't recall seeing a case like that.
No, I think 496-501, but again, 496-501 does not indicate that the hearing examiner has to make a separate finding. it does not say that. It says that if the hearing examiner makes that finding that this person has only non-contact sex offenses and that they have no idea that they're going to commit any other further offenses escalating, that they can find that that person is a level 1, even if they were to find that the risk is moderate. But that's not what the hearing examiner finds in this particular case. The hearing examiner is clear that not only is the risk moderate, that the danger is also moderate in this particular case. And the danger is moderate because of the application of the factors, not necessarily because it's non-contact or contact. Because in any sex offense, you have to apply the factors. And again, when you talk about the non-contact nature, you go back to DOE 496501, and the court is very clear in distinguishing the type of sex offending, non-contact sex offending behavior and the environment in which that took place in that particular case, that takes it out of the realm of being a moderate danger. However, in this particular case, that's not what you have. There he had one victim. Here you have 7 stranger victims. There everything was within his home. Here it's not within the home. It's outside of the home, in libraries, in stores. So you have a different individual before you than in DOE 496501. And that's why I encourage the court to look at the application of the factors when it comes to the dangerousness, the dangerousness finding it.
Let me interrupt you. I just want to make sure I understand this portion of your argument. Are you telling us that under 496501, a hearing examiner is required to make a finding that DOE is likely to place a victim in reasonable apprehension of a contact offense in order to classify them as a level 2, or are you saying that no such requirement exists?
Correct. That is their argument, that the hearing examiner should do that. But I'm indicating that in the case law, when you look at that case, there is no, when the court establishes what the hearing examiner must find, there are 3 findings. It's the risk, the danger, and the efficacy of internet dissemination. The court had the opportunity to say, if it's a non-contact offense, you also must make this finding, but did not. So this is one that's being imposed upon the board because of the facts and circumstances of DOE 496501, where you have a distinguishable case and circumstances from that particular one.
Justice Tan had a question before.
No,
I don't want to, I interrupted you? No? Okay.
In regards to his other arguments, if you look at the motion for expert funds, it's the same thing. It's a generic motion for expert funds that the hearing examiner definitely made a ruling, and it was very explicit. Obviously, non-contact sex offending is contemplated by the board, and the factors apply to them. So you do not need an expert to say that what their risk is and what their level of danger is, especially where you're having, that would be to the risk determination, and they're conceding that the risk is moderate. So an expert would not help in that circumstance anyways. And if the court has nothing further, I would rest on my memo and ask that you uphold the hearing examiner's
We may have
decision.
something further.
Well, I just want to go back to,
Sure.
I'm just sort of grappling with this issue of the dangerousness, right? And the fact that here, while there are multiple instances and multiple victims in different places and all in the public, you know, Justice Rubin's point about the conduct remaining the same, right? And it's just, I'm trying to sort of come to terms with that fact versus the hearing examiner's conclusion that, well, he's escalated.
Well, again, I think the escalation goes from the indecent exposure to the open and gross nature of his offending as opposed to something else. Because if you recall, if you look at the record, he had 2 counts of the indecent exposure, and then he had several of the open and gross.
Well, and looking at, and I kind of charted this out, his history, it's over, you know, since 2004. 2004 is his first, I believe, his exposure.
I can give you the dates of all of them if you
know,
want.
I have them all here.
Okay.
So we're talking about over a 20-year period, right? And so he starts out exposing himself in 2004, and then we have 2017, he puts his hands down his pants, and then 2018, there are 4 of them in the span of 4 months where he does masturbate in stores in pretty much the exact same kind of MO. and once in his car in a parking lot. And then 2019 is when he's in the library, and then there's the teenager there, which obviously is very concerning. So I guess I'm just trying to get at square that, again, Justice Rubin's point about the conduct basically remaining the same, and also the issue of placing the victims in fear of.
And, well, again, DO 496501 doesn't indicate that you must make that finding, but then there's also the 2020 case where he approaches the male person who was delivering.
That's right. In his
and
driveway.
again,
well, I think
looking
he's
at
standing in his
her,
driveway, and the mail carrier comes over and walks by and sees him doing this.
and he's getting her attention. So again, I think with the escalation, the hearing examiner is indicating from the indecent exposure to the open and gross type of behavior, because his indecent exposure was, one of them, his penis was flaccid, he just pulled down his pants. But he's escalated in behavior to now getting people's particular attention, masturbating in front of them, and then fleeing.
But not escalating in any way that gives rise to a thought that he's putting people in fear of a contact offense.
Not in the
so
police
it's
reports.
just worse open and gross lewdness is your point?
I think that you have to look at, again, the continuum, if you're looking from KM, who has other things going on in
That's
his.
distinguishable
Right.
from this.
And this particular case, that's only non-contact sexual offenses. I implore the court to, again, just look at the application of the factors to the dangerousness. With regards to the record, I put in my memo to show the distance he was from these particular victims when he committed these offenses.
Oh, like 4 to 5 feet away.
Correct. Some are, yeah, they're very close in nature. So that is what the hearing examiner is looking at the facts of this particular case. There's no sentence in the record that says they were afraid that he's going to commit a contact sex offense. That's not what we have here. And a hearing examiner should not guess that. But what the hearing examiner indicates is that since past his prologue, were he to commit another sex offense, it likely would be against an unsuspecting adult or a child in a public place. He does not limit that to non-contact sex offense, although he points out that his history is non-contact sex offending.
You can keep going if you. All right, I see no further questions. Thank you very much. These are excellent arguments in a very complicated area of the law. So thank you both very much.
Thank you,
Your
Your
arguments
Honors.
are very helpful to us. Our final case for today is the number 24735. This is Bernat versus HERTNARSKI. And we will hear first from Attorney Novich.
Good morning, good afternoon, Your Honors. Excuse me, Attorney Richard Novich on behalf of the appellant, Jackie Bernat. The trial court conclusion that a 61-year-old woman who had been out of the workforce for more than 40 years was not entitled to a cent in alimony for the years that her husband was employed, making upwards of $9 million, is contrary to common sense and constituted a clear error of judgment. We think that it should be vacated for at least 3 reasons. First, there is no basis to justify the trial court conclusion that Ms. Bernat failed to demonstrate a material and substantial change in circumstance, specifically during the 4 years that Mr. Hertnarski was employed. As set forth in the record, the totality of the parties' circumstances from 2017 to 2020 included the following. Mr. Hertnarski's income at the time of the divorce went from, his income went from 0 at the time of the divorce to upwards of $1.7 million.
How much did he make over those 4 years, just in terms of income? What's the total?
$5.51 million.
And you're arguing, how much are you arguing she's entitled to out of that amount?
At the trial court level, my recollection is that...
After taxes, et cetera?
My recollection is it was around 25%. which I believe
25% after taxes?
25% of his gross. And at the time, it's unclear, given the timing of the Tax Cuts Jobs Act and whether the alimony order here that predated it would be grandfathered such that it would be taxable or not. That much is unclear currently.
If you factored in taxes, we're talking somewhere between 800,000 and 1.3 million. Is that the ballpark?
Yes, it is.
Okay.
In addition to receiving more than $5.5 million of earned income just in those 4 years, Mr. HERTNARSKI also earned or had unearned passive income of over $3.5 million.
That's irrelevant, right?
It isn't. Under the case of Dolan versus Dolan that was decided by this court a couple of years ago, when the court is determining in the first instance whether there was a material change in circumstance, the trial court judge must look at the income earned from assets that were awarded at the time of the divorce. We were not looking for a...
But they can't, that alone can't be a change in circumstance because the former spouse is never entitled to some of that.
So there's a distinction here, respectfully, Your Honor. Under Dolan, there were 2 steps in the analysis. The first step was, under the Alimony Reform Act, the trial court judge must first determine, is there a material change in circumstance? To do that, this court determined that it's appropriate and, in fact, required in the first instance to look at the income that has been generated by the assets of the spouse that were awarded at the time of the divorce, and did the rise in those assets, was it a substantial change? The second step in the process, which I think where Your Honor is going, is assuming that there is a change, can that person be ordered to pay a portion of those funds to the payee, the recipient spouse? And the answer is no. And the Alimony Reform Act clearly addresses that. At trial, we were not looking for any piece of
And that's because ability to pay doesn't include those things, is that right? So that no change in income, active income, means no ability to pay any more than they had before. Is that what that means?
I wouldn't dispute that, Your Honor. I think what you're saying is right.
Counsel, can I ask a question? Because as I was reading through this record, I was wondering, and partly because opposing counsel makes an issue of this in their brief about your client was told by her ex-husband that he got a job January 2017. He starts at February 2017, and she starts to contact him, I believe, shortly after that to try and get information, and then eventually files the complaint for modification in 2019.
That's right.
And I know there was a change of counsel and all of that, but they sort of make it into an issue, the delay, as they called it.
Sure.
And I suspect you might respond, well, it took us a while, or took her a while, her counsel at the time, to get some of that information. But I'm just wondering if there's anything you can state about the time that lapsed between when she found out and when she filed it 2 years later.
No problem at all, Your Honor, and a great question. The record reflects that in 2017, Ms. Bernat reached out directly to her ex-husband to inquire about his quote-unquote thoughts on alimony. She also, at the same time, if I recall correctly, specifically asked him for the documents that he was required to produce voluntarily under the terms of the agreement that he had failed to produce. Fast forward, I think, a month or two, she hires an attorney. The attorney does the same thing. He sends an appropriate and a polite email, would like the documents. By the way, we do not want to file a complaint for contempt, number one, and a complaint for modification. And the response to the email, it's in the record, is there'd be no need to file a complaint, period. The way that it was described, if my memory is right at the trial, was that my client interpreted that as, we don't need to go that route, we will try to work it out. Now we have roughly a 2 year...
What happens during that time, the 2 years?
So, as I was not the attorney of record, all I can say to you is that there were efforts that were made that were to try to resolve the issue that were unsuccessful. The second thing that happened, and it's in the record, and you can see this at this Record Appendix 2, pages 363 and 364. During the time in question, the party's son had an unfortunate hospitalization, to be delicate. And at the time of the hospitalization, Mr. HERTNARSKI was living on the West Coast. There was one parent that was close enough to be able to address that on an immediate basis, and it was Ms. Bernat. So did she focus a lot of her energies on making sure that her son was healthy and okay? Yes, she did. Was that part of the delay? I believe it probably was. But those two things, she believed that her lawyer was doing her best to try to resolve the case amicably because that was the goal. And two, she had a son that was in crisis that she was wanting to make sure that he was taken care of. As part of the issue of retroactivity, which we address in the brief, a couple of things are at play here. Number one, the case law, I think, is crystal clear that a trial court judge has the discretion and the power and the ability to enter an order retroactive prior to the date on which a complaint for modification is filed and served.
So if we thought there were an error, wouldn't we remand to the judge? We're not going to announce some amount or how retroactive it is. It depends on facts and circumstances that have never been litigated.
I agree with you, Your Honor, and I think it's unclear from the judge's findings and analysis. In fact, there are no findings or analysis elucidating or explaining why the judge denied or rejected any retroactive relief at any time of any amount. So one of the things that the court can do...
The judge didn't order any relief.
No relief in...
Going forward, going back, I mean, the retroactivity question's never reached.
Not
right?
at all.
I mean, the judge does say they're back in the position they were in, and I understand why that isn't really a fully adequate response to, yeah, but what about these years? So let's say we were to agree with you, which is a hypothetical, that there was a change in circumstance and that now there was an ability to pay. The case comes down to need in a way, doesn't it?
It sure does.
Okay. So the judge says a bunch of things, but one of them is the judge must consider all the statutory factors and reach a fair balance of sacrifice between the former spouses when financial resources are inadequate to maintain the marital standard of living.
Yes.
Is that what the judge concluded, that there was a fair balance?
The short answer, Your Honor, to that question is it's unclear to me if that's what the judge concluded, but what I will tell you is, in my view and my knowledge of the law, a zero alimony award where the payor has at least $5.5 million of earned income is not a shared balance of sacrifice under any legal
Well, it
statute.
might be if each of them had received assets in the $8 million range in cash and investments, plus additional properties and so on.
So-
Right? It might be that someone could say 8 and 8, 10 and 8, you know, what we're talking about here isn't material. I'm not saying the judge said that at all.
Of course.
But one could imagine that.
Sure. So let me address that in a couple of different ways, Judge. Alimony is to be guided, the Alimony Reform Act instructs us that alimony is to be guided by the marital lifestyle prior to separation, prior to divorce. Lost my train of thought for a second, forgive me.
I'm talking about a balance of sacrifices.
No, I understand. So the amount of alimony is a function of the party's needs, and there are certain cases, there will be certain cases, where marital estate, marital assets are divided and they're significant. There are others where the marital estate is not so significant. The cases that I've been able to find that address this issue, and there have been several cases over the last 15 or 20 years that have addressed the issue of forcing a payee spouse to have to live off of the assets that were awarded to her in the divorce in lieu of alimony. There have been 3 that I've been able to find, and I'd like to go through the 3 of them because I think they answer your question a little bit more directly. The first case that I could find was from 2008, and I believe I've cited it in the brief. It's CDL versus MML. In that case, this court affirmed a trial court's decision not to include the passive income or growth from a payee's assets that were awarded to her in the divorce when calculating her husband's alimony obligations to her. The husband appealed. This court found, and I quote, "It would be inequitable to require the wife, in lieu of alimony payments from the husband, to satisfy her needs and living expenses from investment income from assets allocated to her as part of the division of assets." We fast forward 5 years later, a panel of this court addressed the issue from the opposite perspective, and the name of the case is Tetro versus Allard. In the Tetro case, much like we have in the case that is before you today, The trial court judge refused to award 1 cent in alimony to an economically dependent spouse, and instead concluded that she had the ability to rely upon the assets that were equitably assigned to her at the time of the divorce. Again, a panel of this court concluded that there were, quote, multiple equitable concerns with forcing a wife to use assets awarded in the divorce to support herself. Now, the last of the 3 cases that I was able to find in the last 20 years that addressed this issue head-on is in 2024, the SJC weighed in the landmark case Openshaw versus Openshaw. Now, granted, it was dicta, but I believe that its observation in this point is particularly enlightening. In that case, the SJC concluded that it was appropriate to consider a spouse's savings when determining the amount of alimony that someone should pay in support. In this case, the SJC cited with approval a decision from New Jersey, a Lombardi case from New Jersey, and the Lombardi case specifically says, quote, "It is not equitable to require wife to rely solely on assets received through equitable distribution to support the standard of living while husband was not similarly constrained." This is exactly what we have in this case. The trial court judge made a judgment call that said, you know what, she's got enough assets, she can live off of those assets. It doesn't matter whether Mr. HERTNARSKI has the skill and the ability to generate substantial assets on his own as a former portfolio manager. As the record reflected, the year later in 2021, he on his own generated more than $1.9 million just investing his own assets. Ms. Bernat, as the court found, did not have the same skill set to be able to generate assets to meet the marital standard of living, not a shell of the marital standard of living.
What's our standard of review for reviewing the judge's alimony determination?
Abuse of discretion or clear error of law.
So let me ask you this question. This is akin to Justice Rubin's question, but let me ask it a little differently. At Record Appendix Volume 3, pages 238 to 240, Judge McSweeney did his own alimony analysis as a belt and suspenders approach. Could you tell me with as much specificity as you can, or particularity, why that analysis is outside the range of reasonable alternatives in terms of abuse of discretion?
So I don't have those pages in front of me, and as good as my...
His alimony analysis, where he says, while the court finds no material change in circumstances has not occurred, it will provide the parties with an alimony analysis indicating why it would not be appropriate here. And then he goes on for a page and a half to explain, to delineate why.
You're talking about the findings directly, Your Honor?
Yes. So why are those findings not within the range of reasonable alternatives?
Happy to address that, and thank you for clarifying that for me. So under the Alimony Reform Act, which we are bound to consider, alimony is a function of, bottom line is it's a function of 2 things. It's a function of need and ability to pay. The judge's conclusion, whether she had no need because she had assets or because she had no need, was not supported by the record. Those conclusions did not rationally flow from the findings. Let me address a few of those findings for you. In certain instances, the judge specifically found that she lacked the skill to be able to meet the marital lifestyle. Other cases, the judge addressed the fact that at no time over the course of the post-divorce life was she able to generate sufficient income from the assets that were awarded to her in the divorce to meet even partially meet her reduced lifestyle. So again, we're not talking about what her reduced lifestyle was post-divorce. We're looking at what her lifestyle was pre-divorce, the marital lifestyle, privileged, extravagant. In this instance, the judge doesn't deny and really doesn't make any findings, but the findings, I think, are clear in that her lifestyle dropped. The judge speaks about how she sacrificed certain expenses. She made substantial reductions in her expenses. So there was very clearly a need. One of the judge's other findings, where he addresses the issue of 2019, the judge specifically says that Ms. Bernat credibly testified that at the end of 2019, she was left with $190,000. Now, that's an awful lot of money to me, and I get it if it's an awful lot of money to some others. But it's not about me, it's not about you, it's about what these folks lived their lifestyle. In the very same breath, I believe it was the very next finding, 114, 115, in that neighborhood, the judge says, Her annual expenses were $467,000. He doesn't say that they were excessive. He doesn't say that that was inappropriate. He says that her reduced lifestyle was $467,000. If she had 190,
You're well past your time, but I'll see if our panel chief will let you finish.
You can finish answering.
if she had $190,000 left over from her invested assets, and her needs were her reduced needs were 467, there was a deficit just that 1 year alone of over $277,000. In 2019, the record reflects that Mr. Hetnarski had earned income, or total income, excuse me, of more than $1.8 million, and yet not a cent of alimony was ordered. For these reasons, we suggest that the judge abused his discretion, made clear error of law, and we ask that the case be vacated and remanded.
If there are no further questions, your time has expired, so thank you very much.
Thank you very much.
We will hear next from Attorney Foskett.
Good morning, Your Honors. May it please the Court, John Foskett for the defendant appellee Adam Hetnarski.
Could you move the microphone toward you?
Is that better?
Yes, thank you.
There's a lot to address here in what we just heard, and there's a lot that's missing. Let me start very briefly with this apparent assertion that was made at the trial court that the increase in Mr. Hetnarski's investment assets is itself grounds.
You don't need to address that because he had real income of over $1 million a year. Why isn't that a material change in circumstance?
Because the way this works is in order to determine a material change in circumstances, the court, you file a complaint in court. You come in and say, something has happened that constitutes a change in circumstances. And the court assesses that by looking at all of the financial.
So you view it's a change, right? He starts working.
It's a change.
So you're saying it's not material.
What I'm saying is it's not a change in circumstances that warrants in this case, an initial establishment of alimony. And that's because the way it's supposed to work, and I'll get to why it didn't work that way here, but the way it's supposed to work is you file a complaint, you come into court, you say to the judge, this has happened. You need to determine that there is a material change in circumstances which results in an alimony award. And in doing that, the court assesses all of the financial circumstances of the parties, including all of their assets, which have been repeatedly understated in the trial court by the wife. And then...
Go ahead.
Go ahead. No, I was going to say, then exercising its broad discretion, and the cases all say this, exercising its broad discretion, the court determines whether there is alimony is warranted.
Okay, so actually, I think you just have answered my question, which is you're mushing all three things together, which is you're mushing together change in circumstance, ability to pay, and need. You're saying that you can find no material change in circumstance based on no. I don't read the judge to have done that, but let's say you're right. Let's cut to the chase, which it seems to me is need, right? Because it seems to me that if there were need, then earning almost $2 million a year would be a change in circumstance, and ability to pay would be shown by that income. So let's go to need. And I'm sure you disagree with with the premises of what I'm saying.
It's more nuanced than that. Let's look at what happened here to try to figure out.
I'd like to talk about need, and then
that's what I'm going to do.
Okay, go ahead.
What happened here was she learned that the husband was employed by March of 22, or March 22 of 2017. She knew what she needed to know, notwithstanding claims about being lulled, et cetera. It's clear in the record. There is zero evidence that she didn't have the information she needed.
Okay, but she filed in 2019.
But if I may, Your Honor.
Yes.
What she then did immediately was go out and spend $1 million on a property.
I'm sorry. I want to talk about her need for alimony, not what she does with her money. But her need for alimony, as I understand it, means that anyone whose whose station is not what it was during the marriage, anyone who can't afford the marital lifestyle, has need. Do you agree that that's the need we're talking about?
If that's looking at all of the assets,
Yes.
if that's how it comes out, and the judge has
The
discretion to
judge
determine.
has said explicitly, neither party can live the marital lifestyle. That's in the decision, right?
To be clear, neither party can live or could live the marital lifestyle because if you
Because
look
the
at
money's split in half now, so you can't have the 12,000 square foot house with the smoking room. You can only have a 6,000 square foot house with, right?
But again, that's why you do it the way you're supposed to do it, rather than the way it was done here.
Okay, why doesn't she have need based on that she can't live the marital lifestyle? That's not the same as saying alimony has to be paid, but why isn't that need?
It's need if you take into account all of her assets. And as we point out in the brief, even in their brief, in this court, they disregard $2.5 million of assets. That's all in the mix.
That's not my question. Even $2.5 million of assets, the judge says that she can't, neither of them will maybe ever be able to live the marital lifestyle. So why isn't that the need that we're talking about? I will get in a minute to whether there's a balance of sacrifices or whatever, but why isn't that need?
Because that's not how the courts assess need in terms of viewing all of the financial circumstances. I can't unwrap that because that's what the court is supposed to look at and then exercise its broad discretion to determine that there is a need that warrants alimony.
Need that warrants alimony is different. I'm asking if she has, so the judge says, the court finds that in light of her own substantial assets, the wife does not have a present need for alimony. But he's earlier said she can't live the marital lifestyle. Now, maybe she's not entitled to alimony from him because they both have so much, it's immaterial. But doesn't she constantly, don't each of them have need for alimony, you know?
I'm sorry to try.
I may be wrong. I'm happy to be corrected.
I can't unravel it. And one of the problems with the findings the judge made, let's look at the case that he was given, by the way. The case argued to him was that he should grant general term alimony starting February 2017 until the husband turns 67, which I believe is 1931. That's the case he was presented. And what happened was the husband was terminated from his job, as we know. What they argued persistently, and the only thing they argued throughout the case to the bitter end, was that that was a false termination. He orchestrated it. They put on an expert. They said, you have to attribute.
But they've dropped that claim here.
Well, they did, but they dropped it here, but they didn't drop it in the trial court. And they persisted with that. That was their focus.
Well, one thing I can promise is it's good and dropped.
No, I'm not disagreeing, but it should have been dropped earlier, to be honest with you. I mean, it should have, my point is that that's not what they did. They told the trial judge, this is it. That was the hill to die on. And what the judge did was he said, wait a minute. They were unemployed when they were divorced, both of them. They're unemployed today. That's the result. That's what he found in the part you're referring to. There are references to earlier findings about she couldn't meet this or that, but that's where, I don't mean to be obstreperous here, but that's where it becomes relevant as to what she did before she filed a complaint. She went out and purchased, she decided unilaterally, this is what my need is, this is what I need in order to live the marital lifestyle. So she spends $1 million on a property in 2017. And then, when they finally get around to filing a complaint in May of 2019, she goes right out and there's another $600,000 out the door as a gift to the son, however you want to look at it. So the judge she already was incurring those expenses. She should have come into court and gone through the correct process. So the judge is looking and saying, based on her determination of what the marital lifestyle dictates that she should be living here. No, she's not meeting those expenses. And I hate to keep saying it, but there's also this persistent exclusion, even at this level in their brief, of these other assets. They can't be disregarded. They're supposed to be taken into account by the judge.
The question is only this. Yes, both parties are very rich. Both parties own very nice pieces of real estate, including a house in Truro in her case, and I don't know enough about this apartment. The house in Truro, by the way, seems to have appreciated more than any of her other assets. So, okay, that's fine. They both have lots of assets, but suddenly the husband has income coming in. Not passive income, but from working. Why shouldn't assuming neither of them can afford the marital lifestyle, I just don't understand why some of that mightn't be available for alimony.
It might be, but I can't emphasize enough. We're trying to reverse engineer what is the proper process. That's what we're trying to do, because she made the unilateral determination that this expenditure of $1.6 million is what I need. And then she turns around and tells the judge, this is my need. This is why I need alimony.
I got it. Well, I'm sorry.
So she hadn't made those purchases, would that change your position?
Pardon?
If she hadn't made those purchases that you've been pointing out, would that change your position?
What it would have done is it would have allowed the judge to assess this without already being confronted with her expenditures that she unilaterally decided to make. It would have, again, what I'm trying to say is the way this works is you get news that you think there's been a change in circumstances. And by the way, their separation agreement doesn't define that, all right? But you can come in and say to the judge, here's my complaint. I want alimony now because I believe there's been a change in circumstances measured by all of the financial circumstances. And then it's up to the judge to determine, well, what style is her right to live in now, and can all of her assets satisfy that? But that's not what happened.
I'm sorry, I don't understand what you're saying at all. She's entitled to do whatever she wants with her money that was in the property division. And if she wants to buy a series of houses up and down the East Coast until she runs out of money, she can do it. That doesn't mean that's the marital lifestyle. It doesn't mean anything about it. The judge has to say, what was the marital lifestyle? He can include those assets among her assets in figuring out whether she can live the marital lifestyle, even if she's doing something different than the marital lifestyle. And so let's add back the 1.6 into her pile of money. It's still not enough for the marital lifestyle, right? That's what the judge says.
That's right.
He says even the husband's isn't enough for the marital lifestyle, and he's invested far more wisely than she has.
That's correct. I may not be following because
well, all I'm saying is if someone can't live the marital lifestyle, a dependent spouse can't live the marital lifestyle, then they continue to have some need. If there's no ability to pay, if there's no income, if all someone has, then there's nothing to pay. But if they can't, then up to whatever it is, 30 or 35% under the current law of income could be awarded as alimony to try to equalize things. And if things were equal going in, and suddenly there's $2 million of income, or $1.6 million or $1.9 million, whatever, coming in, then maybe they're a little unequal now. And maybe to try to equalize that, some alimony would be appropriate.
But that's why when the judge found at the time of trial, everybody's unemployed. And that goes to whether or not...
Was the judge asked to address the alimony for the years when the husband was working?
As part of the 14 years.
I understand, but so there was never any briefing below on the question, now that he's unemployed, and if I find that the unemployment is not is his fault and isn't through, it's through malfeasance rather than through, deliberately getting rid of the job to avoid alimony. Was the judge asked, So if that's true, we still want alimony for the 4 years.
No, the first time that argument has been made is here. That was my point about the case that was presented to the trial judge. All the eggs were placed in the basket of saying, nothing has happened here. Run forward, we want 14 years of general term alimony. That's the issue. This is a different case than the one that was argued to the trial judge. And the trial judge, as we say in our brief, what he found based on the case presented to him was correct. Unemployed at the time of the divorce, unemployed today. So that part...
Excuse me, you're about to run out of time, so I want to ask you a couple of questions. And my first one is this. Do you agree with your brother's representation that the amount that your client made during those 4 years was approximately $5.5 million in income?
That appears to be a correct calculation.
Okay. Do you agree that their client was seeking approximately 25% of that?
With this caveat, they are seeking 25%. That's where it becomes important as to whether or not we're talking about 45 months or 18.
Okay.
And that goes, and I don't want to spend much time on it.
I understand that from the record.
Right. So we agree that if in fact there was found to be an abuse of discretion and there should be an alimony award, it's limited to that calculation based on those 18 months.
You're saying 18 months, they're saying closer to 4 years. I get that.
And I see my time's out.
So then my
I think this is
but my follow-up question then, and I think I know the answer to this, and it's probably a question you don't want, but you're going to get it anyway, which is, do you agree with your brother's representation that in terms of after-tax dollars, we're in the range of $800,000 to $1.3 million in that ballpark? And I think your answer is going to say, well, that depends on whether it's 18 months or 45 months.
That's my answer. And it really is, I don't want to spend any more time on it. We've briefed it very clearly that there is absolutely no valid basis for sitting back and waiting until May 2019.
It was excellent briefing by both parties on this case.
Thank you.
Wait. Yep. Okay. Nothing else? All right. Thank you very much. Your time has expired.
Thank you.
Thank you both for excellent and helpful arguments to us. This concludes, and the case is submitted, I should say for the record. This concludes our sitting for today. I'd like to thank the court staff and the court officers for their always excellent assistance, and we stand in recess.